The effect of this provision is that the state of Jammu and Kashmir continues to be a part of India. Nobody disputes it. Nobody ever disputed it. It is a unit of the Indian Union. My Council of Ministers shall take appropriate steps as soon as restoration of normal conditions has been completed to convene a National Assembly based upon adult franchise, suffrage, having due regard to the principle that the number of representatives from each voting area should, as far as practicable, be proportionate to the population of that area. In a way, he was adopting the principles that was adopted by us. The Constitution to be framed by the National Assembly shall provide adequate safeguards for the minorities and contain appropriate provisions guaranteeing the freedom of conscience, freedom of speech, and freedom of assembly. The National Assembly, as soon as the work of framing the new Constitution is completed, submit it through the Council of Ministers for my acceptance. In conclusion, I repeat and hope that the formation of a popular interim government and the inauguration in the near future of a fully democratic constitution will ensure the contentment, happiness, and moral and material advancement of the people. So go back to volume 2, written submissions compilation, volume 2, PDF page 38 again. So in 1949, item 24 was there. Volume 2, PDF page 38. Mullahs, in a football field when there is no play, Mullahs, that time has to be excluded.
There's always a play going around. And
I submit to that.
Who would better know about plays than you, Mr. Sibal?
I submit to that.
Time out, as we said.
Maharaja Hari Singh issued a proclamation delegating his power and authority to Yuvraj Karan Singh, who would function as the ruler of the state. We don't have to go to that. Following his appointment as ruler, Karan Singh nominated 4 representatives from Jammu and Kashmir to the Constituent Assembly in India. But the Constituent Assembly actually was formed in 1951, right? This is our Constituent Assembly. Sorry. Now, December 1947 to September 49, princely states underwent a process of integration into the Indian Union by signing merger agreements or covenants of unionization. The state of Jammu and Kashmir was not a part of this process of integration. That's important. By the covenants of unionization, various princely states entered into covenants with each other to form single units. For example, through a covenant, the princely states of Bhavnagar, your Lordship need not read it because this is the Lordship's want. Junagadh, numerous others formed the United States of Saurashtra. Through a separate covenant, Gwalior, Indore, and 18 other princely states formed the Union State of Gwalior, Indore, and Malwa. Similar covenants led to the formation of Patiala, East Punjab States Union Pepsu, the United State of Rajasthan, and the United State of Travancore and Cochin. Between May 48 to September 49, the states of Saurashtra, Madhya Bharat, Pepsu, Matsya, Rajasthan, and Travancore and Cochin signed revised instruments of accession, which inter alia enlarged the powers of the Dominion Legislature, permitting it to enact laws on all matters in lists 1 and 3, the Government of India Act 1935, and cancelled all previous instruments of accession entered into by rulers of princely states that had entered the covenants referred to above. Your Lordship may note that no revised instrument of accession was signed by the ruler of Jammu and Kashmir. Just note that fact, That's we're talking about December 47 to September 1949. Now, November 1949, through their respective rulers, Raj Pramukhs, the states of Saurashtra, Pepsu, Rajasthan, Madhya Bharat, Mysore, and Travancore and Cochin, amongst others, issued proclamations stating that the Constitution of India, shortly to be adopted by the Constituent Assembly, shall be the Constitution for the state, as for other parts of India, and shall be enforced as such in accordance with the tenor of its provisions. 25th of November 49, following the proclamations above, Yuvraj Karan Singh issued a proclamation for the state of Jammu and Kashmir that the Constitution of India, shortly to be adopted by the Constituent Assembly of India, shall, insofar as applicable to the state of Jammu and Kashmir, govern the constitutional relationship between the state and the contemplated Union of India. We don't have to go through that document because it's all set out here. Then 26th of January 1950, In exercise of its constituent powers, the Constituent Assembly drafted the Constitution of India, which was adopted on November 26, 1949. The Constitution of India came into force on January 2650, repealing inter alia the Indian Independence Act, Government of India Act. The relationship between the Constitution and the state of Jammu and Kashmir was governed by Article 370 of the Constitution. It is evident that both the text of Article 370 and the negotiations that preceded its formulation, that Article 370 could not be changed unilaterally by Parliament. That's of great significance. Then, 26th of January, 1950, same day, in exercise of powers under Article 370, sub-Article 1 of the Constitution, the following consultation with the government of Jammu and Kashmir, the President issued. This is the first Constitution application to Jammu and Kashmir, Order 1950. Under paragraph 2 of this order, matters in the first schedule to the order were declared to correspond to matters ceded to the Union of India through the instrument of accession, and subsequently the power of Parliament to make laws for Jammu and Kashmir was limited to such matters. Furthermore, paragraph 3 of the order declared that in addition to Articles 1 and 370 of the Constitution, provisions specified in the second schedule to the order would apply to the state of Jammu and Kashmir. It's important for us to go to this document, volume 3 of the documents, and it's PDF page 470. Sorry, page 4. Page 4, not 470. Yes, this is the first constitutional order. And kindly note this is on the same day, on the Republic Day that you signed this, do this. That's of great significance. In exercise of the powers conferred by Clause 1 of Article 370 of the Constitution of India, the President, in consultation with the government of the state of Jammu and Kashmir, is pledged to make the following. This order is so and so, so and so. For the purposes of subclause B1 of Clause 1 of Article 370 of the Constitution, the matters specified in the first schedule to this order, being matters in the Union list, are hereby declared to correspond to matters specified in the instrument of accession governing the accession of the state of Jammu and Kashmir to the Union of India, as the matter with regard to which the Dominion legislature may make laws for the state, and accordingly the power of Parliament to make laws for the state shall be limited to the matters specified in the first schedule. In addition to the provisions of Article 1 and Article 370 of the Constitution, the only other provisions of the Constitution which shall apply in relation to the state of Jammu and Kashmir shall be those specified in the second schedule to the order, and shall so apply subject to the exceptions and modifications specified in the said schedule, and to the modification that all references in the said provisions to the Raj Pramukh shall be construed as references to the Sadr-e Riyasat of Jammu and Kashmir. So, if you look at this first schedule, you will find defense, what I had indicated earlier in the instrument of accession. You will find naval military, then you find delimitation, naval arms, atomic energy, preventive detention, foreign affairs, diplomatic relations, United Nations, participation in international conferences, war and peace, foreign jurisdictions, admission into and emigration and expulsion from India, passports, pilgrimages, railways, piracies, maritime, all that your lordships will find. That's part of the first schedule. And then in the second schedule,
about 96 items.
Sorry?
About 96 items.
Yes, 9. It's taken, they've taken the entries from the Constitution.
It's less than the
Some are skipped, but they're not 96.
number of the
Come
entries.
from, see, 31 to 41 is missing.
72.
Yes, there are several that are missing.
It's only the same Sheraton number.
That's correct, that's correct. That's all that there is.
At least one.
This one.
Correspond to the instrument of accession, actually,
Yes.
the defense, military.
No, that may not be correct, Mr. Sibal. The instrument of accession, the schedule which is short, was far more restrictive. These are, you can say these are more elaborate.
No,
but
they
these do
relate
not
to the
correspond.
Constitution. I'm
They-
sorry.
They do not correspond, they're not.
No, correspond in the sense that they relate to defense. That, I'm not saying anything more than that. They relate to defense, they relate to external affairs. That's all that I'm saying, because the entries in the union list.
You read out the second schedule earlier
Yes,
at page 2, if I'm not mistaken, 196.
Correct. I'm not disputing that.
176.
When I said
176.
correspondent, I said the broad heads, that's all that I meant. Then say, this schedule 2, is important. Article 72(1)(c), 72(3), 133, 134, 135.
Just one more clarification. This is by an order.
Yeah.
This is by an administrative order.
Yeah. Under Article 370.
370.
Yes, that's all. That's what I told your lordship in the initial stage. Constitution of India as applicable to the state of Jammu and Kashmir.
Correct.
That's all I meant. That's right, that's correct. Numbers, kindly see these exceptions are at 72(1)(c), 72(3), 133, 134, 135, 136, 138, 145, 151. Articles 80 and 81 shall apply subject to the modification that the representatives of the state in the Council of States and the House of the People respectively shall be chosen by the President in consultation with the government of the state. So that was the variation. Articles 54, 55 shall apply subject to the modifications that references therein to the elected members of both houses of parliament and to each elected member of either house of parliament shall be deemed to include respectively a reference to the representatives of the state in those houses and to each such representative. That the references to the elected members of the legislative assemblies of the state and to each such elected members shall be deemed to include respectively a reference to the members of the constituent assembly of the state and to each such member, and that the population of the state shall be deemed to be 44 lakhs and 10,000. But at the moment it's about 14 million. 140 million, that's 14 crores. Now, Articles 149, 150 shall apply subject to the modification that the references therein the state shall be construed as not including state of Jammu and Kashmir. Then Article 246 shall apply subject to the provisions of paragraph 2 of this order, and clause 2 and 3 of Article 246 shall not apply in relation to the state. So no issue of repugnancy or anything like that. They can't pass laws because the residuary power of the state. Then 259 shall apply subject to the modifications that after the words until Parliament by law otherwise provides, the words and the concurrence of the state to such law has been obtained shall be deemed to be inserted. Article 266 shall apply only insofar as it relates to the Consolidated Fund of India and the Public Account of India. Article 282, 284 shall apply only insofar as they relate to the Union or the Public Account of India. 298, 299, 300 shall apply insofar as they relate to the Union. And 324 shall apply only insofar as it relates to elections to Parliament and to the office of the Vice President. So it doesn't apply to the elections in the state. 324, then 335, and then provisions of this part. 361 shall apply only as far as it relates to President. 364, 368 shall apply, provided further that no such amendment shall effect in relation to Jammu and Kashmir unless applied by order of the President under clause 1 of 370. So, the point that I'm making here is very simple, that the government of the day accepted the fact that our relationships with the Jammu and Kashmir government are on a separate footing. The provisions of the Constitution, unless made applicable through a presidential order and agreed to by the government, shall not apply. The residuary power will vest in the state. It is the state which must pass laws. The government of India can't, under the issue of repugnancy doesn't apply. So, this status is accepted. That's how 370 came into being. And it continued. Yes, that will come to later. Then the distribution of revenues, comes, and that we are not really concerned with at the moment. Now kindly come back to volume 2, of the written submissions, volume 2, page 41. That's what we've shown. Page 41.
The constitution.
So the assumption is that if the president passes a notification for the application of any law to the state of Jammu and Kashmir, he has to seek concurrence. He cannot do it without concurrence. Consultation. So it was a collaborative relationship in a sense. There was a constant dialogue going on. This is what we wish to do, and let's consult the state agrees, which is why most of the laws were made applicable. There was hardly any law that was left. So in a sense, they were incorporated separately in the Constitution of India in its application to the state of Jammu and Kashmir orders.
What happened to currency, for instance?
Currency, was the Sarveri Riyasat, as your lordship knows,
Currency.
Currency. No, currency was Indian currency.
No, because if you see currency in the constitution is governed by entry 36 of list 1.
Yes.
But there is no reference to entry 36 of list 1 in the adaptation order.
But it will come later. There were adaptation orders, subsequent adaptation orders. I'll come to that. I'll show that, your lordship. Because several, this comes in 1954, we have another adaptation order. There are several, give me on the list of several adaptations. We got a list by your lordship.
So were the subjects broadened by the subsequent adaptation order?
Of course, Malas. Of course. They were broadened, Malas. Every state they were broadened. We have an order of 52, we have an order of 54, we have an order of 71, an order of 74. Because the powers were extended, Malas, and the state, Malas, after consultation it was done. The state was ad idem with the union, Malas. I mean, the state itself in its constitution says that we are integrated into India. There was no question. The constitution of Jammu and Kashmir itself says that we are an integral part of India. So where's the question? The only thing is that there's a unique structural system in place, a constitutional structure which was in place, which suddenly, Malas, on the 6th of August was done away with. And Malas, with the greatest respect, though I don't want to use that expression, suddenly, Malas, in Parliament, it was said that we are doing this at 11 o'clock. Nobody knew about it. There was no consultation of any sort. So it was, Malas, as I said, the governor of the state and Parliament, and of course the powers that be, they decided to do this one fine morning and tossed it out. So, Malas, page 41. The Government of India published its white paper on Indian states clarifying the nature of Article 370. The effect of this provision, this is important. We're talking about 1950 itself. The effect of this provision is that the state of Jammu and Kashmir continues to be a part of India. Nobody disputes it. Nobody ever disputed it. It is a unit of the Indian Union. And the Union Parliament will have jurisdiction to make laws for the state on matters specified either in the instrument of accession or by later additions with the concurrence of the government of the state. My lords asked me that question. Steps will be taken for the purpose of convening a constituent assembly. The lordship knows, Malas, this is very important. At that time, when, Malas, we became a republic, 370 was there. And 370 mentioned the Constituent Assembly. But the Constituent Assembly had not yet been convened in the state of Jammu and Kashmir. That was convened in 1951. December. Point is that there was this understanding between the Government of India and the state that we will have a Constituent Assembly which will determine the future course of action. Determine whether or not, Malas, in fact, 370 should be abrogated at all or not. That decision was with the Constituent Assembly. Which is why it is called a temporary provision. Not for any other reason. It's in that chapter of the Constitution. So this whole argument that this temporary provision was 370 was temporary, no. It was temporary because between 1951,
Mr. Sibal, what is the date of this white paper?
50, 90, I'll give you.
No, you're not given the date.
I'm sorry, it's at page 121, just see the date. We'll just give it to you in a minute. I'll give it to your lordship, we'll just. So on the 1st of May 1951 now, Yuvraj Karan Singh issued a proclamation directing the establishment of an elected constituent assembly. March 1950, I'll give the exact date.
Okay.
It is March 1950s. Huh? Can't be.
It cannot be 5th July 48.
It can't be. We'll give the date, Maras. I thought it was March.
Article 370 wouldn't have been then.
But in any case, Maras, the idea is that it's prior to 1951. That's the whole point. Maras. Whatever the date is, Maras, it's prior to 1951. In other words, the constitution envisaged a constituent assembly which was to decide as to what would be the fate of Jammu and Kashmir. 15th March 1950 is what I'm told, Maras. Huh?
15th March?
Anyway, let's not get into this. We'll give it. Why quarrel amongst ourselves in the day? It's prior to 1950.
Sibal, you can verify it and then give a date.
I'll give it to your lordships.